Welcome to another exciting episode of The Legal Anchor. Today we'll be discussing carriage of goods by sea law. Carriage of goods by sea law is a private law aspect of maritime law. Maritime law being the carrying of, or the affairs of ocean governance, I should say. That is maritime law. Ocean governance in general. Carriage of goods by sea law is the private law aspect, as it deals with how individuals interact with the sea, whereas maritime law deals with how countries interact with the sea. With that said, 90% of the world's goods are shipped by sea. As we are right here on the Kingston Harbour, we can see the ships in the harbour. And these ships that are in the harbour, how did they get here? They sailed, of course, but what are the laws governing these ships that are more than likely cargo ships as we look? These cargo ships now came here by virtue of persons being engaged in a contract. Those persons decided that they wanted to ship particular items by sea. When they ship these items, from the point of inception, they would have had a contract. This contract had to have had 5 elements. The 5 elements of a valid contract, as you know, you must have capacity. The person must intend to create legal relations. They must be mentally sound. They must also be bound, willing to be bound by all of these terms. That's just some of the things. So, those 5 elements being present, one may find that they find themselves in a legally binding contract. Thereafter, they have now this legally binding contract. What are the terms in this contract? The terms are the parts of the contract that speak to what the parties have agreed to. So, various terms. The parties agree to, for example, ship. Let's just say that they are shipping cars. They've agreed to ship 50 motor cars. The persons would agree the type of motor cars that they're shipping. They would agree the date that they would like the cars to arrive, and many other things. These things are called the terms in the contract. So once these terms are all there, the contract is not done, because this is a shipment contract. So with it being a maritime contract, or admiralty law as it is called in many jurisdictions, including Jamaica, with it being admiralty, what this now means is that the persons who are agreeing, there are certain things that need to be specified. There's insurance, and marine insurance is different, which we will get into. They're also going to want to talk about how these things are going to be shipped. This is international commercial trade in terms. International commercial trade in terms. This refers to who will have carriage of the goods at each point of the journey, who will hold a lawful title at each point. So, this is what we see with our international commercial trading terms. They are very important. They were brought up, the international commercial trading terms, or Incoterms as they're called in the industry. The latest one is 2010. And there are a whole range of them, from FOB, standing from free on board, all the way to various ones. All of these international commercial trading terms guide the shipment of the goods. This Incoterm is also included in that very same contract, hence the name term, because we have now realized that the word term is referring to what? The parts in the contract that the parties have agreed to. So there's the Incoterm in the contract. There's also the shipment of these goods are also going to be guided by the Carriage of Goods by Sea Act. For Jamaica, we have our Carriage of Goods by Sea Act, and this guides how shipments should be handled. So when the person drafted this contract to ship these items by sea, these persons would have also wanted to ensure that they have their Incoterm. So their Incoterm would have been placed right in the middle of their contract. So we see that they have an Incoterm in there, and we realize that it is extremely vital having an international commercial trading term. So we know that they have to have insurance equally in there. We also know that they're guided by the Carriage of Goods by Sea Act. But there's one more thing that the Carriage of Goods by Sea Act also dictates. Any person who is shipping an item by sea must, and I repeat, must do a bill of lading. A bill of lading is the most important document when shipping goods by sea, because when a transshipment is done by sea, the bill of lading accompanies the goods. It is so important that the Carriage of Goods by Sea Act states that once a contract is drafted for shipping goods by sea, a bill of lading must be drafted thereafter. So we see that this document is extremely important and is drafted based on what is written in the contract. So it has the name of the shipper, name of the items, who is going to be collecting the items, the international commercial trading terms being used. All of those major things can be found embodied on this bill of lading. So we now know that the bill of lading is extremely important, and this forms the basis of most lawsuits in the international community as it relates to the maritime space. So in seeing this, one must ensure that all of these things are done. As such, we must ensure that all of this is done to a good standard. Thereafter, one must also ensure that apart from having their contract done up properly, there's also going to be that they're guided by various charter parties. You have a voyage charter, you have a time charter. All of these things are going to be done. And all of these things we must ensure that they are made mention of in the contract. Voyage charter, is it that they're taking the ship just for the particular voyage? Is it that it is a time charter for a specific time? Is it a bareboat that they just want the boat alone and they will do what they want? All of these things must be taken into consideration. Carriage of goods by sea law is a very exciting area. And this is just a brief overview of just what you can expect, even more. But I won't ruin the surprise, and I look forward to seeing you in subsequent videos. Thank you. Come.
Mr. Reed.
Mr. Dennis, how are you doing?
Afternoon, sir.
Afternoon, have a seat.
Thank you.
Welcome to my office.
Sir, I have a scenario I'd just like to go through with you. You know, I recently purchased a laptop and I saw where I can make some income off it.
Yes.
You know, and briefly, I'd just like to go through some questions with you if you don't mind.
Sure.
So, in terms of shipping, sir, what do you need from me?
What would I need? Well, if you're going to be shipping something, you're here at my law office, so it would be for me to draft a contract for you.
Okay.
So what I would need from you, if I'm going to be drafting this contract for you to ship these items, I would need your name.
Okay.
I would need proof of identification. I would need the name of the company that you represent, or if not, if you're just an individual, that's okay as well. The company that is being shipped to or from, so however the shipment is going, and I will need other details, TRN number. I need to know more about the other company, and I need more details from you as to what this contract will entail.
Sir, what is a contract?
Okay, good question. So a contract is a legally binding document between two or more persons. This definition was given to us by Lord Diplock.
Okay.
And it still stands firm up to today. So that is what a contract is.
So if that's a contract, then how many people are normally in a contract?
Any amount. That's why I said two or more. So any amount can be on a contract.
So, okay, that sounds good. Then how long would the process take then, sir?
You're talking the process of shipping your goods?
Yes.
Well, I cannot speak to that. That would be the shipper. However, as the lawyer, what I can ensure is that your products reach you within a stipulated time. Okay. So you would tell me the products that you're shipping, and when you would like them to reach to you. So I will put in your contract when we will expect arrival of these products.
Well, I was thinking of doing it the shipping, the shipping by sea. So quick question: who would be responsible for? I'm sorry. Who would be responsible for it if any of the laptops were damaged?
If they were damaged, well, it all depends now. When you're shipping goods by sea, we have what we call international commercial trading terms, or INCO terms. These INCO terms are agreed by the seller and the purchaser as to how they want to apportion responsibility of the goods at every step of the way. So we will have to sit down and go through the various INCO terms and see which one best suits you as to when we're shipping these goods, so we know who will be responsible for the goods at every step of the way. So if anything should go wrong, we can know exactly who we're to look at.
Okay, sir. Understood. And noted. So, sir, I was thinking, right?
Yes.
On the specifications, sir, I would like to make sure my supplier always abide by the government's rules and regulations. Sir, so how do I go about this, making sure that the supplier keeps with the specification of the laptops?
Okay, so I understand what you're saying, because the government, these laptops are really, they want them to be at a certain spec, the specs to be. So what we would have to ensure is that, once again, this contract that we're going to draft, we would put it in the contract that these are the specifications of the laptops that you are bringing in. So all of that is going to be in your contract, and that will form a solid basis to ensure that you are protected and ensure that the products you are bringing in are at the standard that you want, because you would have already stated that you wanted them at a certain specs.
Then, if I don't get it at a certain spec, can I sue?
Yes. If you do not get the specs that you require, because remember, as we said, the contract is a legally binding document between two or more persons. So it will be legally binding between you and the person to whom you are purchasing these laptops from. So the person has to adhere to the contract. A contract, what you have to also remember, is that a contract can be divided into three sections. It can be divided into the conditions, the warranties, and the innominate terms.
Okay.
So the condition is a term in the contract. So you have the contract and you have various terms, which are the things you agree. So example, as you just said, the specifications. You said you want certain specifications. If the laptops come and they do not meet that specification that you want, you can actually terminate, you can actually sue them for breach of contract, because they've breached the contract, and you can claim back for your money. You can do what we call under the law rescind, which is end the contract, and claim for damages. So you can immediately end this contract because you do not want any more laptops from them, because they've already reached. So you want to just get back your money. You want to end and get back your money. But bear in mind, this is a breach of a condition. A condition goes to the root of the contract, because what it's saying is that if you breach this, I cannot sell my products anymore. So your products need to be at a certain specs so you can sell to your target market. If it's not, then you'll probably miss the target market that you would like. So that is one thing you have to remember.
Alright, so let me give you an example then, sir. I'd like to give the people a mixture of laptops, right? Different various of colors and so forth. Suppose I get all of them with a straight black, what can I sue them then?
Okay, well that's also comes back to exactly what I'm saying to you now. So the contract is divided into three sections: conditions, warranties, and innominate terms. A condition, as we said, goes to the root of it. A warranty means that there's a breach, but it can be rectified with money. And an innominate term is a minor breach. That you'll just get nominal, which means a very small amount of damages. It's a small amount of money you get. In my opinion, if we were to go to court on the fact that the only issue you have with the companies that have come down is that they're all black, however, they all meet the specifications that you required, everything else was there, but the one thing was that they all came down black instead of the variety of colors that you would like, the court may look at that and say that this is an innominate term. It's a minor breach. The laptops can still be used. they can still be used by students. They still meet everything else, just that they're all black. So therefore, you will find that you may only get a very small amount of damages from the court. The court might say, no, we'll give you nothing because we don't see where you made any major loss. Because the laptop still sold like hot bread, because guess what, people need laptops. So the court will look at all of that, but that's, in my opinion, will be a minor breach. So it would be considered probably an innominate term.
Okay. Alright, I have one more question to ask
Sure.
you, sir. Alright, based off of what you said, right, sir? And I know this that sounds like a long process to me in going to the court and all. So is there any faster way I can get back the money without have to go to the court and all that?
Very good. So once again, in your contract, what we can state is that we will go to arbitration. So we will have the matter dealt with in arbitration. So that is, we will sit down with a trained mediator, and we will have the contract mediated by that person, and we will sit down with the person who has done the breach, and that way we can come to a consensus. And it will be faster and easier than going to court, because we would set our dates that we would sit down, meet, and the lawyer, I would be, of course, your lawyer,
yes,
and whoever the other person is, they would have their legal representative, and there'll be an individual who we have agreed, a mediator, who is a neutral individual, who would understand contract law, more than likely a retired attorney, or somebody who is trained as a mediator, and that person would now go through and listen to both arguments on either side, and then come down to a determination. And this determination will be legally binding.
Okay.
So that would be a much more expeditious way. And also, one more thing I want you to remember, when we draft this contract, immediately what the law states is that when a contract is drafted for shipping goods by sea, a bill of lading must be drafted thereafter to accompany these goods. The bill of lading is evidence of the contract. So it is a paper that follows the goods everywhere. So the contract itself will be lodged. You yourself will have the contract, but this bill of lading will actually do the item. So when the laptops are moving, when they're picked up from your supplier in America, wherever it is, whichever country, when they're picked up there, it was with the goods. When it reaches to the port, it is signed off and handed over to the port. When it goes on the ship, it's then signed off again, handed over to the captain of the ship. When it arrives in Jamaica, it is then once again signed off that it has arrived. So this document, this paper, goes with it everywhere, and it's drafted based on the contract. And it's drafted based on the contract because it's going to have the major things agreed in the contract. The name of the shipper, name of the consignee, name of the various parties, the goods that are being shipped. It will have the condition that the goods are being shipped in. Everything. It's a summary, you can almost call it, of the contract. And that can help us identify if anything should go wrong with your shipment, how we are going to apportion damage and who is to be blamed. Because this document called a bill of lading, notes are made on it, so if the items are damaged, it will be written on there. So all of that you must understand when you're shipping goods by sea.
Alright, thank you so much for your time, sir. I know
You're welcome. Yes, thank you. Okay,
enjoy this.
great meeting with you.